There's another question from Naveenji that says, what is the preferred and quick remedy in case of trespass of a mortgage property?
There is no quick remedy there. Yeah. One has to follow the law.
Trespassing is not provided under the SARFAESI law. It is also not provided under the RBI guidelines. Any property which is trespassed, who will take the remedial actions is only the owner of the property or even the mortgagee. So that is the under the code of criminal, or that is something where these trespassing is covered. And if the possession is with the borrower, then borrower can take as remedial actions. And if the possession is with the lender, then the lender can take the action as far as the trespassing or encroachment is concerned. This is what is my understanding. Sanjay ji, in case you want to add.
No, you are right. There is no provision under SARFAESI or RBI guidelines for trespassing. So you have to go to the general law. The one thing what I can add here is creating a trespass is a very steadfast way of the borrower to defeat SARFAESI and create a litigation. We see that in so many cases that they go and create a trespass so that when we try to take possession, there is a third party claim, which also then one needs to fight it out. Yes, it takes some time to close it. It is not always valid, but it takes some time.
So good morning, everyone, and welcome to our weekly webinar series. Today at episode number 166, we are continuing the episode and our conversation with respect to asset reconstruction companies, or ARCs as we call them popularly. We have somebody who is a very renowned person in this industry. We have Mr. Sanjay Tibrewala ji. Mr. Sanjay Tibrewala is MD and CEO of Phoenix ARC Private Limited. He's a chartered accountant, a company secretary, and a cost accountant with more than 30 years of experience in the area of finance across manufacturing, banking, financial services. The last 17 of these years have been with Phoenix ARC, initially as a CFO and currently as MD and CEO. Phoenix ARC is part of Kotak Group, and it's a leading ARC in India with an asset under management in excess of 14,000 crores. Sanjay ji was part of the initial team at Phoenix ARC and has witnessed and influenced the changes in the ARC industry in the past decade. And he's actively involved in the entire gamut of distressed asset business, acquiring corporate and retail portfolios and single assets from various banks and financial institutions all over India, restructuring of distressed companies and resolution of NPAs. I think today we have this fortune of having Sanjay ji's wisdom with us with respect to his experience of how ARCs have changed over the past decade and what is the role that they are playing today. So we are very happy to have him. Over to Anil sir, please.
Thank you, Ankit. And today it's a good day for us. We are at 166 episode of AAA Weekly Webinar Series, and we have a noted expert on the subject that we are dealing with. Thank you very much, Sanjay ji, and it is really our fortune and pleasure that you agreed to spend this time and for the purpose of this education, which is totally free. We have not even monetized this YouTube channel. Before we start and go to the subject, I will say, Sanjay ji, in case you can say something about you and your company, please.
Sure. Thank you, Anil. Thank you, Ankit, for the kind words. And I want to start by thanking AAA on two counts. One is obviously inviting me here to this webinar, and second is for actually doing a knowledge series on ARCs. I think this is the third one, and I attended one of them, and I really like the way the entire gamut of ARC regulations are being covered by AAA in a phased manner, obviously, because their regulations are quite a handful. Quickly about me, I think Ankit has already said a lot. I have been with Phoenix for close to 17 years now. Phoenix ARC is part of Kotak Bank. It is ranked amongst the top 5 ARCs. We have an AUM of close to 14,000 crores. And over the last 17 years, we must have acquired debt in excess of 1 lakh crores spread across 400 odd transactions, and paid a price of close to 30,000 crores for those acquisitions. Against these, we have also recovered about 23,000 crores till now against those NPAs. A lot of it in a hostile manner, and some of it in, by way of restructurings, etc., which we typically consider as non-hostile kind of basis. We must have acquired debt from all the banks and NBFCs in the country. Well, almost all. I am sure some little bit here and there would have got left out. And just to add one last bit is, we are rated AA by CRISIL, and that is one of the highest ratings for any ARC in this country. And once again, thank you, Anil. Thank you, Ankit. And I hand it over back to Anil.
Thank you very much, Sanjay. And it is good to know that you have an asset under management, which is about 14,000 crores and fully backed by Kotak Bank, which is the most respected bank in India. And also, you have acquired more than 1 lakh crores of assets in your experience. So definitely, we are going to get answers to our practical difficulties when we interact with our audience. The audience is also free to ask questions, raise their hands. Just a little bit of cap that we are going to give about a recap that we have done in the part one. We discussed SARFAESI law sections in part two. We are still at part two because the RBI directions, RBI guidelines and governance, it is absolutely little longer. It is very detailed, and we would like to cover all, including practical aspects. So we are on RBI master directions 2024. In the last webinar, in the last episode, we have discussed this RBI master directions. What is the minimum net owned funds, which is 300 crore that everyone has to bring up to March 26. Then registered ARCs can only undertake assets securitization and reconstruction subject to strict prudential norms and RBI directions. ARCs can act as resolution applicants under Insolvency and Bankruptcy Code if they have 1,000 crores of net owned funds and comply with the governance conditions. Investment in other ARCs is allowed but must conform to group exposure norms. Deposit taking is strictly prohibited. ARCs must have a board-approved acquisition policy detailing due diligence and valuation methodologies. Acquisition of financial assets must follow transparent fair value principles and cannot involve related parties except via auctions. Asset must be acquired on a cash basis with originators required to allow at least 2 weeks for the due diligence. That is also one of the conditions. ARC may only use their funds for resolution related restructuring, not fresh funding, not creating fresh capacity. Disclosure of asset acquisition and originators are mandatory in the financial statements. So this is what the guidelines today that we are going to cover is starting from paragraph number 10 of the master guidelines from RBI 2024. And that's very important. Once the ARC acquires or takes the assignment of a financial asset, then the paragraph 10 starts how the plan would be made for realization of financial assets, the formulation of a resolution plan, complete realization. So each ARC, in fact, every ARC shall, it is mentioned in the RBI guidelines that every ARC shall within the planning period, maximum of 6 months from acquisition, formulate a plan for realization of assets. And that plan may include one or more of the following strategies. Now, what I'm trying to take is the 6 strategies that are mentioned in the RBI guidelines. One is the change in or takeover of the management of the borrower's business. Second is sale or lease of the borrower's business subject to RBI enabling guidelines. I have seen the RBI has not issued any enabling guidelines for this option 2. 3, rescheduling of the borrower's debt. It is also happening. 4, enforcement of security interest under SARFAESI law. This is the most common. Then settlement of dues, which is also called one-time settlement, OTS. And then 6 is the conversion of debt into the equity of the borrowing company. And when the debt is converted, there is a possibility that the overall control and ownership maybe partly or majorly is transferred to ARC or the nominees of the ARC. Here at this moment, I would like to ask a question to Sanjay. Out of these 6 options of realization or resolution of a stressed asset, which one is the most popular and why? Sanjay, please. Sanjay, you are mute, please. Please unmute yourself.
So option numbers 3, 4, and 5 are the popular ones, which is one is you take a debt, you restructure, give it 2 years, 3 years to repay, depending on the financial capability of the borrower. If restructuring is not possible, then you look at SARFAESI assets, take possession of the assets, and in fact that is a law also. The law itself is called SARFAESI, Enforcement of Security Interest. And settlement of dues is another one which is more popular with retail, and it is more popular in cases when borrowers have money or they are able to raise money from somewhere to make payment one time. But settlement is more popular in retail, is less popular in corporate, because if the borrower would have money to make a one-time settlement, he would have typically paid it to the bank itself rather than it ending up in the hands of the ARC.
So out of these 3, rescheduling, enforcement, and settlement, still I believe the SARFAESI is being used for most of the cases. As you have rightly said, for retail, it is the SARFAESI which is more actively being used, and for larger corporate loans, it may be rescheduling or even settlement is also not possible. But even SARFAESI, see, when we use SARFAESI Act, I think the company cannot continue. So the business of the borrower will in fact close in case we use SARFAESI. So why can't we use this change in or takeover of management as we use in insolvency and bankruptcy code? What are the difficulties in changing and taking over the management? This question you can answer now or after I give some kind of process education about change in the takeover of the management. What you prefer?
No, I prefer to answer later. Once you have run everybody with the guideline, then people will appreciate my answer better.
So then I would see the first of all the realization policy period as the ARC must have a board approved policy specifying the realization of assets should not exceed 5 years from the date of acquisition. This is basically to enforces time-bound recoveries and accountability in ARC operations. This 5 years can also be extended by ARC board, and it can be extended up to a maximum period of 8 years from the date of acquisition. And this is also only after we record the justification for extending it to 8 years. This is ensuring long-term flexibility only where the strategy justified. But in case ARC is part of a multi-creditor committee for resoluting the corporate debtor or a borrower, then the ARC can also accept a resolution period which is even more than 8 years, but it should be coterminous with the other secured creditors. So even if it exceeds 8 years, so it's the board specified step, because the ARC's board is very, very important. There are so much of obligation which is on ARC board. The ARC board must specify actionable steps to realize the assets within 5 or 8 years, and it actually gets renewed periodically. So the investor's right. Now, again, it is my duty to say, like, in case this repayment plan or realization plan is not successful within 5 or within 8 years, then what are the remedies available with the qualified buyer or uh, with those original lenders? This is provided in Section 7, subsection 3 of SARFAESI Act. It says that in the event of non-realization under subsection 2 of the financial assets, the qualified buyers of an asset reconstruction company holding security receipts of not less than 75%, not less than 75% of the total value of the security receipts issued under a scheme by such company shall be entitled to call a meeting of all the qualified buyers, and every resolution passed in such meeting shall be binding on the company. So this particular resolution would be very important. It requires 75% voting, and then whatever the resolution is passed, that will be binding on the company. So this is something which is important as far as this plan for realization of assets is concerned. But then when we talk about the measures of asset reconstruction, so the first one is, which is actually the paragraph or clause number 11 of the RBI guidelines, change in or takeover of the management of the business of the borrower. First of all, the scope and objective is also mentioned in the RBI guidelines, and it says that the ARC may initiate change or takeover of the management of the borrower to recover dues, ensuring fairness, transparency, non-discrimination, and non-arbitrariness. Key regulatory alignment, because Section 9, subsection 1A also empowers, and then Section 15 is regarding procedural compliances. When we read Section 9, subsection 1 and Clause A, it actually is very clear. Clause A says, the proper management of the business of the borrower by change in or takeover of the management of the business of the borrower. Now, it starts with, without prejudice to the provisions contained in any other law. That's a non-obstante clause. Without prejudice to the provisions contained in any other law for the time being in force, an ARC may, for the purpose of asset reconstruction, provide for any one or more of the following measures. Namely, first is the proper management of the business of the borrower by change in or takeover of the management of the business of the borrower. That is the first power given by SARFAESI Act to ARCs under Section 9, subsection 1, Clause A. So that is the power of the ARC. That power is actually further the manner and effect of takeover of the management is also mentioned. It is also provided in Section 15 of the SARFAESI Act. Although there is a detailed procedure which is explained, and we will discuss this in the subsequent slides. So it also says that in case full recovery has been made, then the ARC must restore the management to the borrower. Unless the ARC has acquired controlling interest by debt to equity conversion. By debt to equity conversion, the RBI says that there should be some grounds for effecting change or takeover of the management. And those grounds are mentioned in the RBI guidelines to say the borrowers are doing deliberate defaults despite resources. That is willful default. And you see, willful default when no payment is made despite adequate cash flow. No payment is made and the transactions are being routed through non-lender bank to avoid payments. Siphoning of funds, falsifying records, mismanagement, borrower acting against the interests of the creditor. Borrowers are incompetent or there is leadership vacuum, losses due to incompetent management. So the key managerial persons are not even appointed. So these are the guidelines that then only in such cases the management can be taken over. The unauthorized, like there are further more instances has been given where the ARC can take over the management of the borrower unauthorized disposal of secured assets in case the secured assets are disposed without any ARC's approval, which is at least 10% or more, then the management can be taken over by ARCs. Imminent insolvency, the ARC can always see that it cannot meet the debt obligations. So therefore, somebody will file insolvency, unapproved compromise. So then the other grounds which are mentioned in the RBI guidelines is the insolvency, business discontinuation. So in case the borrower discontinue some of the businesses without even discussing with ARC, which contribute at least 10% of the turnover, assets are damaged, material business alterations without even the permission of the ARC, promoters are disputing between each other, diversion or misuse of the borrower funds, fraudulent transactions. So all these are reasons for takeover of the management of the borrower. However, there is an eligibility which is before the ARC can activate change in the management. The minimum exposure of the ARC must be at least 25% of the total borrower's asset. Then the 60% consent is required. 60% creditors' consent is required if multiple secured creditors are involved, at least 60% in value, including the ARC, which is initiating takeover of the management, must consent. And the total asset that has been defined as the latest audited balance sheet figures, that is what is considered as latest. So what I'm trying to say is that this requires 60% creditors' consent, and the policy of the takeover. The policy of the takeover, every ARC must have a board-approved policy for taking over the management of the borrower. There should be in the policy, it should be clearly mentioned how the due diligence will be done, how the investigation of the affairs of the operations will be done. There will be an independent advisory committee, which will be having some delegation from the board, and independent advisory committee must assess the financial condition of the borrower unit, business viability, time frame for recovery, and recommends whether takeover or change is required. Then at least two independent directors of the ARC, must be the part of this deliberation, and the decisions must be minutized. When these operations or when the change in the management is operationalized, the ARC must identify suitable personnel or agencies to run borrower's business, and it is actually ensuring recovery within the time frame. Now, when we see this part, Sanjay, the ARC must identify suitable personnel or agencies to run borrower's unit. So, is there any such agencies in India who are specializing this task of managing and running the borrower's businesses? Like presently under Insolvency and Bankruptcy Code, the RP or the IPE, they are supposed to be like they have the powers to run the business of the borrower. But under this SARFAESI law, as per the master guidelines of RBI, how do you feel that in case the management is taken over, how the same will be run with the same efficiency? Yes, Sanjay, please.
So, see, I don't think there are any agencies which have a all-encompassing expertise to run a business. But it is always possible. Suppose, we are talking about a steel unit. Now, steel or textile or, engineering, which are very commoditized kind of a business, then it is always possible to get expertise from the market, a CEO or, a plant head who will actually run the borrower's business. Run the unit, or maybe a sales and marketing personnel for actually selling the products. So there is no one agency, but I think with some effort, it is always possible to find people. But that is also a challenge when you take over, because one has to find the right person with the right experience of turning around a sick unit. Running an existing proper unit versus turning around a unit which is not making money, that requires a slightly different set of expertise.
So when we see this, all these guidelines from RBI regarding takeover of the management of the borrower unit or borrower company, and getting 60% consent from the creditors, placing on record all these conditions which has been provided by RBI, do you think that in case any ARC attempt to take over the management of the borrower, then the borrower will start litigation because of all these conditions which are stipulated in the RBI guidelines?
So
Any
Anil,
such experiences in the industry?
the experience of takeover of management under this guideline has been really not there in the industry. There have been one or two small cases where somebody has tried to do it. I know for sure that at Phoenix, we have never even attempted of doing something like this. And why is that? I will just try and explain from my perspective at least.
Yes, yes.
So there are two or three things. One is, finding, like I said, finding the right kind of team which will be able to turn around a distress unit. Yes, certain industries, a lot of team people might be available. Certain industries, there might not be enough expertise. Second is the risk of litigation. A borrower's unit, if we decide to take over, there is a lot of litigation, a lot of fight that is bound to happen. And we are seeing that in IBC also. See, IBC also is a subset of taking over the unit from the borrower. That is the fundamental of IBC. So litigation is the other piece. There are two other small things. One is a RBI requirement that the management be handed back to the borrower.
Yeah.
Now that is fraught with a lot of challenges. Taking over is easy. You throw out the borrower, throw out his people, etc. But the moment you bring the borrower back in, he will raise a lot of litigation, a lot of hue and cry that my unit has been made a mess of, maintenance not done, quality deteriorated. I mean, all sorts of allegations can get thrown. So
Right.
that is a very largish risk that the ARC would run when they are taking over the management. And to my mind, is one of the largest reasons why not many such trades have happened. And the other large risk is liabilities. When I take over and run a unit, I'm liable for whatever happens in the unit because I am the operating person who's responsible. So that liabilities also tend to be a factor in the mind of the ARC when you're looking at taking over. I'm not saying that's the only thing, but a mix of all of those factors is why not many cases have happened on this change of management. And since then, what happened? 2017 IBC came. 2018-19 IBC became popular. Now IBC itself is another version of change in management, except that now there is no ARC responsible, but there is an independent third party who is regulated in his own right by an IBBI, a resolution professional who is there to run the unit. So with IBC coming in and becoming popular, the the allure or the aura of any changes happening under this change in management has actually become zero now. We would prefer, instead of me running, I would prefer to put it in IBC and give an independent professional the job of running the unit.
So even I would also like to add something for assuring a smooth takeover of the management. What are the provisions which actually were given to the insolvency professionals in the IBC? One was the moratorium, that nobody can disturb the company till the CIRP is continuing. Such moratorium is not in the SARFAESI Act and for the takeover purposes. Two, that the law has given the powers to resolution professional for taking reports, and every company employee would be reporting to the resolution professional. And then the clean slate, that it can be sold to any other person. No past liability will actually be passed on to the new management in case somebody acquires the company under the IBC. These are the three things which are not there in the SARFAESI, which can be used by ARCs. Now, see, like in case this particular measure, this particular way of resolution or realization of assets is supposed to make popular, then some amendments are required in the SARFAESI law, similar to what powers have been given in the IBC. So I think we can take two, three more slides on this, the difficulties on taking over the business under SARFAESI law by ARCs. So it is also says that, as you rightly said, conditions for restoration of the management, that is also supposed to be captured in the policy of the ARC, which is board approved policy. And then the rights and the duties of the ARC borrower and the new management. ARC must clarify the new management's role, which is limited to the debt recovery. Now, if the new management's role is only limited to the debt recovery, so the entire management, it requires entire management. It requires directors on the board. It requires a collective decision. In case it is possible that the management is taken over for a limited purpose, that is where any kind of taking over the management with a limited purpose. Have you ever done, Sanjay? Because I'm giving you a couple of things to kind of say, in case you have approved a restructuring proposal from the promoters, where the promoters are saying that this is the way we will run the business for the next 3 years. This is the way we will repay you. And for this particular 3 or 4 years period, which is a kind of repayment period as per the restructuring plan, can ARC stipulate some kind of agencies to monitor, some kind of cash flow management agencies, some kind of auditors which can be considered as a perpetual auditors, so concurrent auditors? Has this ARCs like kind of done this or been doing this in their restructuring proposals? Sanjay.
We have been, Anil. So see, if we restructure the debt and give the borrower 3 years to repay, then we also want to make sure that the operations are run in the right manner, right efficiency, and the borrower is not again going to his old tricks of siphoning of funds, etc., so that we can get paid. So a lot of the measures that you're talking about, I mean, let me tell you what we do as a normal standard thing in restructuring. So, there will be a TRA account, there will be a monitoring agency, which will either, most cases, it will be post-facto monitoring of cash flows. And in some cases, we will also do pre-approval of cash flows. So, any disbursements from the bank account needs the ARC's approval or need the monitoring agency's approval. So a monitoring agency to track and monitor the funds is an almost given kind of stuff. Do's and don'ts, like the private equity industry works. You won't do the following things without taking my approval. For example, setting up a new business line, doing any other settlement, taking any other fresh borrowings. There will be a lot of such conditions that we'll put on the borrower. Where we think that the operating management of the borrower is not up to the mark or needs to be professionalized, we also insist on a professional CFO or a plant manager, as a professional to be appointed, so that the day-to-day operating business of the borrower is run by a professional, run in a transparent and professional manner. Generally, our documents will also give us a right to appoint directors and auditors. We would not enforce them unless it is a very grave kind of scenario or we have a complete lack of faith on the auditors or on the other directors of the company. So we do enforce a lot of stuff which are similar to takeover of management under SARFAESI.
See, Ankit, you have done some kind of work for the asset reconstruction companies for management of cash flows as a concurrent auditors or as a special investigation about the activities of those companies which are under restructuring plan, and you have been appointed through ARCs. Can you just share your experience? How have you been doing it, and how it is beneficial for the successful implementation of the restructuring plan as submitted by the promoters? Ankit?
So we have done this for multiple industries, and depending on one industry to the other, there's certain internal controls that anyone would expect to be in place wherever the company is of a sizable, of some reasonable size. And when we have reviewed the company's performance, try to understand if there is leakage in revenue, try to understand if there is something which is inflation in cost, we have always realized that that such companies where some kind of hanky panky is happening have very weak internal controls, and you normally see that either the promoter or one person who is dedicated to the promoter is behind every decision that is taken. You would normally see in those companies that the people under the management or under the directors or under the promoters have very less say, and they would then want to take every decision based on the promoters uh, decision or the promoters say. And of course, cash is always a big involvement in all such cases. So whether it is sometimes a business has an inherent possibility of having a lot of cash revenue. Sometimes there is, of course, leakage in terms of cost, that is inflated cost that happens. So this is the general idea, and when we kind of tell the ARCs or the banks who have appointed us that this is what is happening, then normally you able to use that as part of the negotiation with the promoters, and sharing with the promoters that the valuation that they are offering is less, because that revenue or that inflated cost, when it comes into the picture, or and it is adjusted, the valuation is adjusted for these changes, then the valuation numbers change. That allows for better negotiation. At the same time, it also helps in the ARCs or the banks making a case of fraud against the promoters wherever the evidence is very sharp. So these are the things that I believe help the ARCs in such circumstances.
Good. Thank you, Ankit. So, like, just let me continue a little further, because see, in this planning for takeover or for the entire planning for the realization of assets, financial assets, independent advisory committee is very important, which will have to be structured by the ARC. The members of the independent advisory committee must not have any interest in ARCs except their remuneration for services. Now, the procedure, what has been defined in the RBI master guidelines, first of all, there has to be a notice. ARC must give 60 days notice to borrower stating intention to take over the management and inviting objections. The first litigation starts here, because every borrower will give objections, and in case the objections are not handled, then litigation. So the second is the objections reviewed by the independent advisory committee, recommendations submitted by ARC board. The board's decision, board must issue a reasoned order within 30 days. After that 60 days notice, decision must be communicated to the borrower. So therefore, it takes 90 days time, minimum 90 days time, plus the time for the litigation to actually start the effective change over of the management. This is what is the procedure which is defined in the management. And the second part that we have in the clause 12 of the RBI is that the ARC has the power to sell or lease the entire business of the borrower. And it was basically subject to the RBI's enabling guidelines. The RBI has not issued any enabling guidelines under which the entire business of the borrower can be sold or can be leased out to anyone. Sanjay, is this right that RBI has not issued any enabling guidelines for this part of the option?
Yes, that is correct.
Okay, that's correct.
But I must just add here,
yes.
After IBC, I don't think this guideline is ever going to come, because that is also encompassed within the whole IBC framework currently of selling off the entire business of the borrower in a transparent manner.
So the next option available with the ARCs to restructure or kind of realize the assets is the rescheduling of the borrower's debt. For this also, the ARC needs a board-approved policy, and then the borrower's viability must be seen, must ensure that the borrower remains viable after the restructuring. The restructuring should not harm security receipt holders, and asset must preserve appropriate asset classification. So this is something which is important for rescheduling of the borrower's debt. Sanjay, your comments are required on this option for realization of assets.
So for large borrowers, rescheduling of debt is one of the most important parameters which is used, because obviously the borrower doesn't have capability to pay his debt one shot. So rescheduling is done for 3 years, 5 years. And while before doing the rescheduling, we would typically ask the borrower to provide a business plan. The business plan will have a lot of details of how the money will come, how the business will be run, what sort of revenue, what sort of EBITDAs will be generated, and what cash flows will be generated, how it will be paid off, etc. And we would do a detailed analysis of that. And basis that, once we are satisfied that this is a optimum kind of a thing, then that's when we go ahead with this option.
So what is this part that the rescheduling should not harm security receipt holders? Can you just put some light on this? What are the circumstances where the security receipt holders can be adversely impacted?
So let me give you an example that an ARC acquires the debt of 200 crores from a bank and issues SRs worth 100 crores to the security receipt holders. Now, while restructuring, while looking at it, you find the ARC gets a restructuring proposal of 25 crores. So to my mind, purchase at 100, restructuring at 25 is something which will get covered here, unless the ARC has done enough work to see that 25 is the best and the optimum number that can be recovered and nothing more can be covered here. So that is what is the this is supposed to protect the SR holders who have put in, say, 100 crores on the debt.
Okay, so the next option before the ARCs is to enforcement of security interest under SARFAESI Act, starting from Section 13, and that is where the process involves identification of asset, giving notice under Section 13(2), then taking all actions under Section 13, subsection 4 of SARFAESI Act, including identification of property, making an application to district administration, which can be a district magistrate, a district commissioner, the CJM, CMM, depending upon the jurisdiction, and then taking an order from these statutory judicial bodies, and then taking the assistance from the police or from the Tahsildar or from the court commissioner, whosoever is appointed by these judicial authorities. So these police people or judicial or the court commissioners or the Tahsildars, they would actually assist the bank or the bank appointed agency for taking over the physical possession of the asset. After taking the physical possession of the asset, then the assets can be sold by the ARC, and the signatures of the ARC would be valid transfer of the title to the buyer. So this is what is the enforcement of security interest. In fact, AAA Capital Services Private Limited, in fact, we came in this business right on the very first month when this SARFAESI law was promulgated in India, and we were the first person to be empaneled by State Bank of India for outsourcing the entire process, including the property identification, making applications to judicial authorities, taking orders from them, police tie-up, taking physical possession, deputing security, finding buyers, and then finally getting it auctioned. So far, AAA Capital Services has actually taken, it has been given by the banks more than 42,000 cases, all the banks, 42,000 cases that we have handled so far, and under SARFAESI. And we are not talking about recovery cases where we have the job of enforcement of security and trust. So this is the most successful option available with the ARCs as well as with the banks under SARFAESI Act. So where the 60% of the secured creditors' consent is required. So in case a ARC takes over one part of the loan, so then the ARC will have to reach out to the other creditors to accumulate 60% consent for enforcing Section 13, subsection 2 notice to the borrower. So then the acquisition of the secured assets by the ARC can acquire on. See, there is only one condition, that in this enforcement of security interest, when the assets are being sold, there is one option that the ARC can also acquire the assets in their own balance sheet. But that must be done in the auction and with the transparent disclosures that the ARC is actually acquiring this asset from the public auction for their own consumption. So your comments are required on this entire process of enforcement of security interest, Sanjay.
Like you said, Anil, enforcement of security interest is one of the most followed measures for recovery amongst banks, amongst ARCs, amongst everybody. And this has been there for a long period of time. So the law has got pretty well codified here, and there is enough and more judicial precedence on what to do, how to do, and how to follow the whole process. So yes, there is a public auction option. There is a bilateral or a private treaty option, which one can do for selling the asset. A private treaty is preferred only once you have at least tried an auction once, so that the seller doesn't get accused of, any hanky-panky ways. But I must add here is that because enforcement of security interest has been there for a long period of time, the whole system has also learned how to misuse, or how to avoid enforcement of security interest. So there are all sorts of delays that happens. The moment you give a notice, the borrower goes to DRT, files a securitization application. It takes months for that application to decide. Thereafter, there is a whole process of getting approval or consent from district magistrate, tehsildar, or whichever is the local body designated currently. That consent takes a lot of time. Their approval takes a lot of time. And part of it is also because they are flooded with cases. There are certain jurisdictions in this city where, in this country, where if you go to the DM, he will show you he has got a backlog of hundreds of cases lying for permission for security, for enforcement of security interest. So while initially this was a very quick methodology for recovery, nowadays it does take anywhere between 2 to 3 years for even doing enforcement of security interest. Sometimes it happens early, but most of the times it takes that amount of time. But having said that, it is still very effective, is what I can say.
Yes, I think you said yourself that it is now, it's since 2002, and that this law has seen various judicial orders from Honorable Supreme Court. And each and every order of Supreme Court that we have seen, in fact, we have seen all orders of Supreme Court of India, and we have seen in the recent past, for the last 4 or 5 years, after the amendment which was made in 2016, and after this insertion of Section 26 capital E into SARFAESI, after the activation of SARFAESI, which is Central Registry, and now the Supreme Court has in fact dealt with most of the disputed issues. One, the Supreme Court has clarified that the right of redemption with the borrower, there is a limit to that. That is, after the sale notice is released in the public newspaper, thereafter the right of redemption with the borrowers is extinguished. Then there is no power with the CMM or CJM or Deputy Commissioner or DM. They don't have to adjudicate anything. We have a database of various states, and now we see that barring a couple of states in India, in every other state, the DM order or CGM order now is received within 2 to 4 months. So in some cases in Delhi, the CGM or the CMM orders are even received within 1 month. So that is where we are saying that there are in fact many instances, more than 30-40% cases, the property is realized, money is realized within 6 months from the invocation of section 13 subsection 2 because the stays are removed. Now, so many judgments from Supreme Court and High Courts that the DRT is giving stay, and there has to be a minimum fee with minimum payment which is required to be made by the borrower that before the borrower can make a essay before the DRT. And also, when we compare, let us understand that there is an option of insolvency which is not applicable and effective for most of the assets. The second option is the RDB Act, which is the filing an application before the DRT. And the third option is the SARFAESI. I still feel comparatively SARFAESI is much faster. It is much robust now. I'm not saying 5 years or 6 years back. Over the last 5 years, in fact, since 2016, the impact of amendments on 2016 actually have in fact worked a lot for the betterment of implementation of SARFAESI law. And the banks are able to recover a lot out of the SARFAESI law. And we see in our office itself that successful auctions of properties under SARFAESI, we do about 30 to 40 successful auctions in a month. We have about 200 people working under this. We have a detailed database, a very high database of all those people who buy properties under SARFAESI. So our success rate is about 30 to 40 properties in a month across India. So SARFAESI is much better now. While I'm saying this, I'm also trying to compare with IBC and the other options available, like the arbitration or other options available with the ARCs or any other lender. So this is where we actually are now. The settlement of borrower dues. See, very simple, like the board approved process must be there. The independent advisory committee must recommend it, and the preferably a lump sum payment. NPA of the recovery must exceed realizable value. Staggered payment require the independent advisory committee's role. So this is where I think again your comment is required. How normally an ARC view a proposal of one-time settlement, because I understand that the borrower keep giving these kind of proposals to ARCs or to the lenders. Yes, Sanjay.
So to my mind, one-time settlement is a very preferred option because it means that I can get a quick exit in 3 to 6 months from the repayment of the dues. The problem always is the quantum. If a borrower gives a one-time settlement, they expect a very large discount, and the ARC might or might not be in a position to give such a discount because of your purchase price, timelines, etc. But I must also add that any settlement has become quite complicated since 2022 October, when RBI brought this whole concept of IAC and board approval in the picture. So earlier settlements used to be, like any institution, we would have a settlement matrix. Settlement up to certain limits will be done at a lower level. Above certain limits will go to the board. But 2022 RBI came with a requirement that all settlements need to go through IAC. IAC has to be fully independent. And after IAC approval, it has to go to the board. So while we don't disagree with the merits of getting an independent view on settlement, but we think that, taking everything through this process was just very cumbersome. And this included even retail also. So, a home loan settlement of 20 lakhs, 50 lakhs also. So the industry made several representations, and finally, I think sometime in January or February, if I remember, the regulation changed, and RBI put in a threshold of 1 crore for IAC. So less than 1 crore can go through a internal mechanism, and more than 1 crore still needs IAC approval. So that I think is fair and to some extent reasonable. Yes, going through IAC, going through board does elongate the timelines because independent authorities have their own restrictions on how they want to go through it. They want a week's notice, etc. They might not have time, and board also, which we think also is that slightly excessive because even banks don't have that requirement of greater than 1 crore needs to go to IAC and board. And banks is an organization where there is much more public money at stake and much larger organizations. Having said that, small cases, specifically retail, this is a preferred mode of option, especially home loans, affordable housing loans, etc. We see that, once you start SARFAESI, issue notices, there is a very strong chance that the borrower will come, the borrower will realize that his house will go away, will come and, pay the dues, give a settlement, take, borrow money from friends, relatives, etc. For unsecured loans, so this is the only option because there is no SARFAESI, there is no IBC, unsecured personal loans, credit cards, and those sort of stuff. So net, this is a good and also one of the most used options for smaller cases within the ARC industry.
How normally this IAC is made? With mostly what the ARCs do for making this IAC?
So, see, independent advisory committee has to be completely independent of the ARC, not connected to the ARC in any manner. And it also has to have somebody, who understands finance, somebody who understands legal. So the way we created our IAC is that, the we created a panel of names, went to our board for with those names. The board looked at it, and then the board identified a 3-member independent advisory committee, which will actually look at cases. They looked at the experience of IAC members, their independence, whether it's there or how their independence can be seen, and accordingly, then the IAC got constituted.
Good, Sanjay. I think the last option or the measures that is provided in the RBI guidelines is the conversion of any portion of debt into equity of a borrower. There is a requirement of ARC must have a board-approved policy outlining principles and procedures of debt to equity conversions. Evaluation and turnaround strategy must be very clearly placed on record, which is applicable to all financial assets with turnaround potential typically burdened with high defaults and unsustainable debt. Restructuring should be based on a detailed business plan, realistic cash flow projections, and operational forecasts. Sustainable debt must be separated, and the residual unsustainable portion may be converted into equity. ARC may influence the entity's turnaround but must not directly manage or run the business. ARC's equity shareholding post-conversion must not exceed 26% of the total equity. So when this is restricted to 26% of the total equity, then that means that the management is not taken over by the ARC. It is only and only for the purpose of turning around. Like when we were seeing the first option, which was taking over the management, there was one option that in case you take over the management, you will have to give the company and management back to the borrowers. But however, there was a one exception, and that exception was unless you have converted the equity. So equity, in case there is a restriction of 26% on the total equity. So even in that case, I don't think the management can continue with the ARCs. Only part of the management can continue with the ARC.
Sorry, if I can just interject here. There are two options here. There is one for up to 26 and there is one for greater than 26. There is a greater than 26 option, which has a different and some more strict, some more regulations and controls around it. Yeah.
Now, this is what you are referring to. Then this option says that the ARC may exceed 26% of the equity cap if they comply with the following. Now, the following is the ARC meet the net owned funds requirement on a continuous basis. At least 50% of the ARC's board comprises independent directors. Debt to equity decisions are taken by a committee with majority independent directors. Monthly valuation of acquired equity shares marked to market is conducted. Such conversion must comply with SARFAESI Act, RBI guidelines, FEMA, RBI Act, Companies Act, SEBI regulations, and FDI limits specific to sectors. This is something which is very important, which you in fact said that, and this is option where the entire management can also be taken over in case it has been done cautiously. So then the shareholding limit of 26% is not applicable. It can actually be more than that. Sector specific management panel is another thing. ARC should explore maintaining a panel of sector specific management entities individuals. These experts may be appointed to manage restructured entities professionally, ensuring the business survival. So what I'm trying to say is the one we see when we talk about this is management entities. So when we talk about IDRCL, the structure of IDRCL is just like this management entities, because see, the NARCL takes the assignment and then hand it over to IDRCL. So is it the IDRCL which is considered to be a management entity, Sanjay?
So I don't think IDRCL is a management entity under these regulations, but yes, that is the model that they have, is that the acquisition entity should have, the entity which owns the asset should be separate, and the entity which manages should be separate, so that there is an independent entity which is managing the loan and managing the recovery. I think we can deliberate on the merits and demerits of both the options, because otherwise all the other 27 ARCs, the managing is merged with the acquisition entity and there is only one entity which is doing the business. We can discuss the merits and demerits, but yes, the whole model of IDRCL is, distincting the management from distincting the basic acquiring entity.
So Ankit, in case there is any questions from the public or anyone would like to ask a question from the expert or from us.
So we have a question that I think, but this will take time. I think this is from Priyanka Narang, and she says RBI has issued guidelines for settlement of accounts. Can you discuss on those guidelines? So I think that can be completely new topic or a fresh topic, which will take some time.
I think Sanjay can take a call whether it can be done in 2 minutes.
I can summarize and explain in a couple of minutes. So, the RBI guidelines on settlement of accounts are broadly about, one is the settlement process, which they talk that you have to route everything through an independent advisory committee. And after the approval of independent advisory committee, it has to go to the board of directors, and the board of directors should have minimum two independent directors while they decide on this. That is the process part. And the second is the actual settlement part, where they have some conditions which talks about that the net realizable value of the assets is an important factor to be considered when you are looking at the settlement, and also the fact that the ARC should have considered all the other possible avenues, like for example a SARFAESI or an IBC. All of those should have got considered before a settlement option is being considered, or is being put on the table. And it also says that the settlement should be in lump sum, but it doesn't prohibit in terms of doing it in one or two lots, one or two, three installments also. But the preference is that the one-time settlement should be paid one time and the account should be closed. So that is what is broad summary of the settlement guidelines.
Right. Thank you so much for that. We can then move on to a question from Naveen Anchan. The question is that, is there a need for giving 30 or 15 days intimation of sale every time prior to issuing sale notice?
See, I can answer this. Like, the first notice of 30 days is mandatory. I think the second notice, in case of the first sale notice is not successful, then I think the second notice can be reduced to 15 days. If it is not correct, Sanjay, I think it is correct.
No, to the best of my knowledge, that is right. Every time you put an asset for sale, you have to give a notice to the borrower of 15 days. Which means he gets a chance to go and litigate. But yeah,
Right.
that is the law. So one has to be fair.
There's another question from Naveenji that says, what is the preferred and quick remedy in case of trespass of a mortgage property?
There is no quick remedy there. Yeah. One has to follow the law. Right now,
Trespassing is not provided under the SARFAESI law. It is also not provided under the RBI guidelines. Any property which is trespassed, who will take uh, the remedial actions is only the owner of the property or even the mortgagee. So that is the under the code of criminal, or that is something where these trespassing is covered. And if the possession is with the borrower, then borrower can take as remedial actions. And if the possession is with the lender, then the lender can take the action as far as the trespassing or encroachment is concerned. This is what is my understanding. Sanjay ji, in case you want to add.
no, you are right. There is no provision under SARFAESI or RBI guidelines
Yes,
for
yes.
trespassing. So you have to go to the general law. The one thing what I can add here is creating a trespass is a very steadfast way of the borrower to defeat SARFAESI and create a litigation. We see that in so many cases that they go and create a trespass so that when we try to take possession, there is a third party claim, which also then one needs to fight it out. Yes, it takes some time to close it. It is not always valid, but it takes some time.
And if I can extend this question to tenancy, what would be the best way forward wherever there's a tenancy in place, or the tenancy has been created post the mortgage, some of those complications? What is your experience with handling those kind of complications?
Tenancy post mortgage is a complication, and one has to go through the court process to get it vacated because that tenancy is illegal. It, if the lender's permission is not taken, then the mortgager could not have provided for, could not have created the tenancy. So depending on state to state, it takes its own time to get it, get it sorted out.
Right.
I can add here, Ankit, in view of various Supreme Court judgments and various High Court judgments on this particular subject, the present conclusion is that if there is any authentic tenancy rights which has been created before the mortgage and it did not came to the notice of the mortgagee, then even if it is in the notice of the mortgagee or not, the tenancy is upheld and the tenancy will complete its tenancy lease period. Secondly, if the tenancy is created after the mortgage, which is mostly people take home loan and they are not living in that home, but they just give it on rent. That is a bona fide tenancy, and that is also protected by the High Courts and Supreme Court. Because most of the home loans that has been given and most of the executives, they actually try to invest their surplus income into the properties and then they give it on rent. So in all these cases, in case they give that property on rent, then the tenancy is protected during the continuation of that lease period. The only thing is that the tenant should be benefited. What is the relationship between the tenant and the owner? So all these things are completely classified now. And the second thing, which is very important, is that if there is any tenancy dispute, the jurisdiction has now been shifted to DRT rather than any other tenancy court. The DRT will understand and adjudicate whether the tenancy is authentic or tenancy is fake and is created to create hurdles to SARFAESI actions. This is what is the various High Courts and Supreme Court laws which says.
We have a question from Mr. Pawan. Mr. Pawan says that at what point in time in debt recovery process should guarantors be engaged for enforcement actions? So to my experience, I think SARFAESI guarantors are made part of the entire process since the very beginning. Number two, in case you're talking about any guarantees which are for companies, for debts taken by companies, there again, the thought process ideally should be that in case those guarantors have some assets and that comes to the knowledge of the ARC or the banks, they should ideally initiate action in DRT or in NCLT against those guarantors ASAP. With respect to this, the earlier the better, because there is a possibility of the assets being transferred or given away. Maybe Sanjay ji can add more of practical experience in this situation.
So I agree with you, Ankit, what you're saying. The only thing that I want to add here is, as per law, guarantors are jointly and severally liable. And so the right of a lender is to take an action against the guarantor at any point whenever the guarantor thinks fit. And you are right, SARFAESI notice, when it is issued to the borrower and guarantors, everybody put together. But the earlier the better. I mean, there is always a risk of guarantors alienating property. And so the earlier one can file, the better. And there is also always a risk of limitation kicking in. So one has to make sure that action gets initiated before limitation of any sort can kick in against the guarantors.
I think, Ankit, we've already exceeded 10 minutes from
Yeah,
our scheduled
I
time.
took that liberty since we had the benefit of having Sanjay ji
Still,
with
there
us.
are lot many questions, and I think we should also keep the time in consideration. So, conveying my heartiest thanks to Sanjay ji for participating and sharing his experiences, which are huge, and our audience have definitely got benefits. Any questions that remained unattended, that can be attended offline, and we only can say this is our way of learning. There's nothing else. It's a collective learning process that we've started. Thank you very much. Thanks a lot.
Thank you.
Yes.
Thank you.
Anil.
Thank you,
Ankit.
Sanjay ji. Thank you, everyone. Thank you.
Thank you.